Okay guys, back for part 2, state citizenship versus U.S. citizenship. Now I'm going to read to you what is a sovereign citizen, and this is an updated version because the way it was, the way the laws were written and everything, that state citizenship was based on, they used to call it white state citizens. Now when I read different things to you, it's going to still mention that and talk about that. But this is the more updated version because remember, at that time, America was racist, or more racist, or basically white people who were fully in control at that time. And that was who was here. Because it certainly didn't apply to black people, it certainly didn't apply to Hispanics or Mexicans, it certainly didn't apply to Indians. So it was white people who were considered the free white sovereign state citizens. But those have all been amended and changed to now include everyone. So when you hear me saying that and talking about the white state citizen, understand that was, because many people out there, you're smart, and you know, people say to me, well, you know, that was based on white supremacy and the white thing. Yeah, it was. But the fact of the matter is that it's been changed to include us all now who are American, you know, born citizens, native-born Americans. So, you know, understand that, and I get that, and I know that white supremacists use a lot of this or whatever. But when George Washington or the forefathers came here, they were just trying to free themselves from the slavery bonds of Europe, of King George, etc. So it's the same thing. So don't let that bother you. And there are things that I don't agree with also within the parameters of the common law, and that gets into like the abortion issue, homosexual issue, and so forth. And you know, I believe they were against interracial marriage and all this other stuff that's just ridiculous to me. So there are aspects and elements of everything that I don't like or that I do like, and vice versa. So I'm just reading to you what the law and what the issue is that most of you have never heard about. Because I guarantee you most of you have never heard the expression, I'm a state citizen and whatever. Maybe more so now than back years ago when I talked about this stuff and people looked at me like I was some crazy, nutty alien. But as the years go by or went by, I would get phone calls every now and then. Hey Kevin, you remember me? I used to work with you, blah, blah, blah. And you know, I used to talk about that stuff and I used to laugh at you. Well, now I live in Florida and I've run into a big group of people. I moved to Texas, and you know, that's what happened. So anyway, let's get going because there's a lot of dry reading, and bear with me on this. And I want to read this to you because, like I said, I just want you to understand that it's been updated because I'm going to be reading some stuff from the original kind of state citizenship stuff that's going to mention the whole white thing and so forth. And that's just, I just want to make it clear and explain to you what that meant. What is a sovereign citizen? A sovereign is a state citizen of the California Republic or a state citizen of another one of the 50 common law states of the Union. A sovereign is not a federal citizen or U.S. citizen. However, because of state citizenship, a sovereign is a citizen of the United States of America. There is a legal difference between the two. A sovereign has revoked power of attorney from any government agency they may have unknowingly contracted with in their lifetime. A sovereign is a citizen that has revoked and surrendered their Social Security number. They have also sworn an oath to protect and defend the people and the Constitution of the California Republic, 1849, or their own common law state against all enemies, foreign and domestic. A sovereign is a sui juris, which is defined in Black's Law Dictionary as of his own right, possessing full social and civil rights, not under any legal disability or the power of another or guardianship, having the capacity to manage one's own affairs, not under legal disability to act for oneself. Now that term civil rights in there may not mean the exact same that we talked about earlier with civil rights. There are some of the wordings that I guess, sound the same or mention the same, but we're not talking about the same civil rights that Congress has granted to the U.S. citizens. So don't let that throw you off. A sovereign adheres to the common law. What it really means, excuse me, is as long as one is responsible for their own actions and maintain the sui juris status, one can do whatever one pleases as long as two conditions are met. And I already read this to you, but I'll redo it or reread it again. Do not infringe on the rights of others or damage their property or person, and keep all agreements entered into knowingly, willingly, and voluntarily. And once again, that thing, persons, don't let that throw you off. In this meaning, it's talking about you. I mean, could have been worded better, maybe, but anyway, that's just an overview of that. The other thing I want to say to you is that there's great debate about the whole state citizen, U.S. citizenship thing. There are groups of people out there who work hard and diligently trying to decipher the codes and laws and explaining the original meanings and intents of it. Now, I've been a part of some of these groups over the years, and I want to make sure you understand that you have to make up your own mind and research and look at it. And like I said, I'm not the master of this stuff. I don't, to be honest with you, I hate it, because I hate having to look into law and learning all this stuff. But I've learned that through necessity I must learn this stuff, because we're being enslaved every day, and if you don't know your rights, you're going to be trumped on, and that's what's happening in this country, and I hate it. So through that necessity, I'm learning and have learned a lot of this stuff. Like I said, I'm not a master of it, but I feel I have a good grasp of it. But anyway, so there are two groups of people. Richard McDonald is the head of the California State Citizen Movement. And there's a gentleman by the name of Payman Montejade. He's the founder and president of the Freedom Law School that teaches this stuff, but he's against the state citizenship, saying that he used to believe in it and think it was real until he started reading and researching the cases more, and feels that it's not what it means. It means you are both the same at one time, and Richard says no. And you know, I've been to the debates between those two guys many years ago, and I have to make my personal feeling is I think Richard is right with the state citizen, because the evidence is here. It's showing you that, and I'll get into that, it's showing you that there's something different was created with the 14th Amendment. And that's what this whole thing really is, when it got heated, was when the 14th Amendment got added to the Bill of Rights. And we'll get into all of that, and I'll explain that to you, and hopefully it'll make sense to you. But with Richard and Payman, it's like Malcolm X and King. They were both trying to accomplish the same thing. They were just doing it in a different way. And it's the same thing with these guys, you know. So I love them both for what they do, and and try to help us, excuse me, and help us with this information. So all right, this can be a little bit of dry reading here, but you got to understand this, and you got to hear it out. I'm going to try to cut as much as I can, you know, of it, so that it's not too boring and dry. But here we go. Which citizen are you? This was done in November 1989. I believe this was on the TV show Dateline America. What kind of citizen are you? Are you a 14th Amendment federal citizen, or are you a citizen of the several states as described in the Constitution as it was originally intended by the Founding Fathers? Are you aware there exist in this nation two separate and distinct classes of citizenship? To begin with, I must define what the definition that the original Constitution used when it referred to the citizens. The phrase citizen of the United States has a specific meaning in the original Constitution for the United States of America, 1787. The definition and intent of the Constitution was that it described a free-born citizen of the several states. The 14th Amendment added a second distinct meaning to this phrase. So now the phrase citizen of the United States has two separate and distinct meanings, which are not compatible with each other, and indeed in the later issue will be shown to be at odds with one another. They are, number one, A freeborn white state citizen in the several states is an individual whose inalienable rights are recognized, secured, and protected by the various state constitutions against state actions and against federal intrusion by the Constitution for the United States of America in 1787. Now here we go with the word individual and inalienable rights. It's being used there in the sovereign sense. Like I said, you got to know the difference. Inalienable rights, you know, there's that debate. We already went over that. I'm not going to go over that right now or again. And the individual is kind of tied in with the person. But like I said, there are words that you have to use it to mean not the federal meaning at certain times. And I believe that he's using that in that sense right here. So anyway, let's go back. The 14th Amendment federal citizen who is a second-class citizen, a juristic person, a citizen of foreign or interstate commerce, one who has congressionally granted privileges that are almost equal to the white citizen. I say almost because these privileges are secured against a debt of submission to the morality legislated by Congress, including income tax. These individuals are subject of Congress, alien juris, under their protection as a resident of a state. A person enfranchised to the federal government, the incorporated United States, defined in Article 1, Section 8, Clause 17. The individual states may not deny to these persons any federal privileges or immunities that Congress has granted to them. This specific class of citizens is a federal citizen under amity international law. As such, they do not have unalienable common rights recognized, secured, and protected in the constitutions of the states or of the United States of America 1787, such as allodial rights to property, the right to inherit, the unalienable rights to work and contract, the right to travel, life, liberty, and happiness, among many others. Thus, the federal citizen is a taxable entity such as any other corporation and is subject to pay an excise tax for the privileges that Congress has granted them. The white de jure citizen is a state citizen by birth and race to common law first. Then, as a consequence of his state citizenship, he is a citizen of the United States of America second. He owes his allegiance to his state of domicile first, and then to the union of the several states. The 14th Amendment citizen is a de facto citizen, a citizen of the United States, spelled with a small c, and we'll get into that. Corporate citizen of the District of Columbia is territories and federal enclaves per Article 1, Section 8, Clause 17. First, as a consequence of this citizenship, he is allowed to be a resident within the several states. For this and other privileges, he owes his allegiance to the United States Corporation per Article 1, Section 8, Clause 17. First, then to the state of his residence. Note that domicile and residence are not synonymous. See Black's Law Dictionary, 5th edition. The Internal Revenue Code's definition of the term citizen is identical to the wording of the 14th Amendment and can only apply to the subjects of Congress. The Social Security number, a badge of slavery, is the main registration number of the de facto 14th Amendment citizen. So Congress can tax their subjects, slaves, wherever they are resident. Now, which citizen are you? A white state citizen or a de facto resident? You must decide. This is a personal decision, and notify the appropriate government officials of your status with respect to them. Be prepared though, the United States District of Columbia does not want their slaves to escape. If they did, the profit of the Federal Reserve would dry up and you might lead the exodus out of Egypt. See? Very informative right there. So you got to understand this. The next part I'm going to read to you, I'm going to cut a little bit because I don't want to make it too long and dry. It's called Legal Words and Consequences. Excuse me. First, you must understand that this is an educational form, and I will give you the meanings that are utilized by the various governmental agencies to deprive you of your rights and property. The word person, as it is used in most of the statutes, refers to the same person as defined in the so-called 14th Amendment. It does not include everyone, as you are led to believe. There are several court cases that define who is that specific person, and one of those cases is von Valkenburg versus Brown, 43 CAL 43. Next, the term United States has three different distinct and separate jurisdictional meanings. This has been stated in Hooven and Allison Company versus Evatt, 324 United States 652. There the court stated, the term United States may be used in any one of several senses. It may be merely the name of a sovereign occupying the position analogous to that of other sovereigns in the family of nations. It may designate the territory over which the sovereignty over which the sovereignty of the United States extends, or it may be the collective name of the states which are united by and under the Constitution. Each of these definitions have completely different jurisdictions and cannot be mixed. Do you know which of the meanings are being utilized when they say United States? When in doubt, ask. This always brings some type of answer, and you will at least know for yourself what they are doing to you with your permission. Very crucial. And forgive me, all the reading and doing this stuff is making me a little hoarse or what have you, so and mispronunciation of certain words that I really don't know a lot about. So, all right. This is a little longer part, but it really, in my opinion, sets it all off, and it's very detailed as explaining to you a little more in depth. So let's do this. Is the United States government guilty of genocide? When this nation was formed, when this nation was formed, I guess, also, each of the individual states of this union had their own citizens with a capital C, as defined in the Constitution, but then came the so-called 14th Amendment. For clarification purposes, the term citizen, when used in the constitutional sense with a capital C, shall designate a state citizen, as per the intent of the founding fathers of this nation. When used with a small c, as it is used in the so-called 14th Amendment, shall designate the federal citizen, which is a different class of citizen. In law, every letter in a word is important. The capitalization of a specific word means a specific thing. The use of the same word without the capitalization may mean something else. In this case, it does. The citizen does not include the citizen. The large C or capital C does not include the lowercase c. The word resident, capital R, does not include the lowercase r for resident. D. There is a clear distinction between national and state citizenship. U.S. citizenship does not entitle citizens of the privileges and the immunities of the citizen of the state. K. Tashihiro versus Jordan, and it goes, it's a lot of other legal cases that go into that. I don't want to read it all. Black's Law Dictionary, 5th edition, agrees with the distinction between different classes of citizenship. Privileges and Immunities Clause. There are 2 privileges and immunities clauses in the federal Constitution and amendments. The first being found in Article 4 and the second in the 14th Amendment. Section 1, Sentence Clause 1, the provision in Article 4 states that the citizen of each state shall be entitled to all privileges and immunities of citizens in the several states, while the 14th Amendment provides that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. Pages 1078 through 1079. Note the lack of capitalization in the wording used in the 14th Amendment. This specifically means that the word citizen, small c, privileges, immunities are not the same as in Article 4. The state of California was admitted to the Union of the United States in 1849 by an Act for Admission of California into the Union, Volume 9, Statutes at Large, page 452, and was admitted into the Union on equal footing with the original states in all respects whatsoever. The state of California was required to have its own citizens, who were first state citizens, then as a consequence of state citizenship were American citizens, known as citizens of the United States with the capital C. There were no specific class as this, but traveling and protection by the United States government while out of the country. They were generally called citizens of the United States with the capital C. The Constitution for the United States of America, 1787, used the term citizen of the United States in Article 1, Section 2, capital C, and numerous other sections, each time with capitalizations. This referred to the sovereign political body of state citizens. This citizen is entitled to all the privileges and immunities of the citizens of the several states under Article 4. Congress utilized the same term, citizen of the United States, qualifying it with a small c, to distinguish the federal citizen. In the so-called 14th Amendment, these citizens have only statutory rights granted by Congress. Thus, Congress and most of the judiciary have acknowledged that an amendatory act cannot alter the original intent of the Constitution. Therefore, Congress did not alter the meaning of the term citizen of the United States, capital C. It still remains the same, a citizen of a state. In the past, the judiciary, without the distinction being properly brought forth, have made rulings based upon the federal citizens who are residents in a state, not state citizens domiciled within their own state. The statement by Chief Justice Taney in Dred Scott versus Stanford 19 HOW 393422 in defining the term persons. The judge stated, persons who are not recognized as citizens. See also American and Ocean Insurance Company versus Cantor 1 PET 511, which also distinguishes persons and citizens, large C, capital C. These were the persons that were the object of the 14th Amendment to give to this class of native-born persons who were residents in the Union of the United States citizenship and authority to place other than the white race within the specific category of citizen of the United States. To overcome the statement in Dred Scott Supra that only white people were citizens and all other persons were only residents without citizenship of the states, Congress then passed the Civil Rights Act of 1866, 14 Stat 27, the act of Congress called the Civil Rights Act, 14 U.S. Stats at Large, page 27, which was the forerunner of the 14th Amendment amply shows the intent of Congress. All persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States, and such citizens of every race and color shall have the same right in every state and territory of the United States to full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens. Again, note the lack of capitalization. This was the intent of Congress, not to infringe upon the Constitution or the status of the de jure citizen of the several states. The term person did not include the white de jure state citizen. It was never the intent of the 14th Amendment to subvert the state's authority or that of the Constitution as it relates to the status of the de jure state citizen. People versus Washington 36C, 1869, overruled on other grounds. French versus Barber, 181 U.S., and it goes on. The so-called 14th Amendment uses language very similar to the Civil Rights Act of 1866, and Harlan J. in a dissenting opinion quoted from the veto message of President Johnson his interpretation of its meaning. It comprehends the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, as well as the entire race designated as blacks, persons of color, Negroes, mulattoes, and persons of African blood. Every individual of those races born in the United States is made citizen thereof. Elk versus Wilkins, 112 U.S., 94, 114, so on and so on. It was the intent of the so-called amendment that the de jure citizen in the several states were not included in the terminology, as they were by birthright citizens as defined in the preamble and could receive nothing from this so-called amendment. No white person born within the limits of the United States and subject to their jurisdiction owes his status of citizenship to the recent amendments to the federal Constitution. Van Valkenburg versus Brown, 43 California Sub 40 CT 43. This last part is where it gets deep, and I want you to fully, it's all deep, but understand this. This is the last of it. And this is how it all ties in. In 1913 came the Federal Reserve Act, our downfall. Then in 1924, Cook versus Tate, which stated that citizens of the United States, wherever they are resident, are subject to the income tax, which is based upon citizenship of the United States, spelled with the small c. Now, the government cannot tax only the citizens of the United States under the so-called 14th Amendment and not tax the white state citizens. If they did that, there would have been a revolution here in America. So the Federal Reserve banks deliberately caused a crash of 1929 congressional record and made all the people who had saved for their old age lose their money that they were saving. Then the government in 1935 instituted Social Security, and this was controlled and handled by each state on a state level. So the state could handle their own citizens, capital C, the sovereigns, and residents under the so-called 14th Amendment. Then in 1939, the U.S. government repealed the Social Security Act, which is a little known fact, and reenacted it into the 1939 Income Tax Code with a new intent and meaning, classifying everyone who has a social security number, a taxpayer, and a federal citizen of the United States under the so-called 14th Amendment. Now, the U.S. government, knowing this, under prompting of the Federal Reserve, stated that the people of America were saving too much money, congressional record, and therefore should pay an excise tax, congressional record. This was the victory tax to help out World War II. But in 1 year, the government made so much money on this tax, they decided to repeal the 2-year limitation on this victory tax and telling no one. They made it a permanent tax on the citizens of the United States who have a social security number. There you go. Webster's Third International Dictionary, page 947, defines genocide as this: the use of deliberate, systematic measures as killing, bodily or mental injury, unlivable conditions, calculated to bring about the extermination of a racial, political, or cultural group. 2. Or destroy the language, religion, or culture of a group. The writer believes that the United States government is guilty of using the so-called 14th Amendment and Social Security to force unlivable conditions. You cannot work if you don't have a Social Security number, to accomplish genocide, as it is described above, to enlarge and maintain a revenue base for the profit of the Federal Reserve. Forced integration is destroying the white political cultural group known as state citizens in all the states. Now, anyone can do their own research and arrive at the same legally correct determination that I have. I did not cite all the congressional records, but you could look them up if you were so inclined. The proof is there, so what are you going to do about it? Continue to be a victim of genocide? That's some deep reading right there. So, kind of enough said on that. It's a lot to digest and so forth, but that's what we're trying to teach and tell you as Americans. What's going on? How we're being tricked into paying taxes and having social security numbers and driver's license and birth certificates, etc. So right now, I just want to go over some of the highlights of just different things that talk about the separation of state citizens and federal citizens, and that have been collected through the years in law books and journals and codes and so forth. I mentioned to you the whole Van Valkenburg versus Brown case. Now, this case is an 1872 case that shows the true intent of the so-called 14th Amendment. Because what people don't understand is, and I'll get into it, but I'll read this little part to you first. Purpose of the 14th Amendment. The purpose of the 14th Amendment to the Constitution of the United States was to confer the status of citizenship upon a numerous class of persons domiciled within the limits of the United States, who could not be brought within the operation of the naturalization laws because native born, and whose birth, though native, had at the same time left them without the status of citizenship. Such persons were not white persons, but in the main were of African blood, who had been held in slavery in this country, or having themselves never been held in slavery, were the native-born descendants of slaves. This was created, you guys. The 14th Amendment was added to deal with the newly freed black slaves. What were they going to be granted with citizenship? Now, from what I understand, there were 2 states that were willing to give the newly freed black slaves full, sovereign, free state citizenship rights. New York, believe it or not, and I forget the second. New Hampshire or Maine, one of those, I'm not sure, but anyway, I didn't have time to go back and look it up, but I know New York for sure. We're willing. That's what this is all about. As always, comes down to us, black folk. Let me give you this. The California Government Code on the right, Section 242, defines who is a citizen. Remember that the District of Columbia is not a state of the Union, but is the seat of the government, and you, as a U.S. citizen under the so-called 14th Amendment, are a citizen of the District of Columbia. Here it is. Sovereignty of the state. 242, non-citizens. Persons in the state, not its citizens, are either citizens of other states or aliens. This next part is saying, I'm glad that you all agree that you can't be both at the same time, because the Federal District Court in San Diego ruled in 1979 that federal law only protects and applies to foreigners, persons, and aliens, and does not apply to citizens. Now, if you are a citizen, you are exempt from all federal laws, but subject to the national laws. Now, aren't you glad you got a Social Security number so you could become a subject of Congress? And you voluntarily contracted away your citizenship to become subject to federal laws. United States versus Otherson. Upon introducing the, I'm sorry, it's kind of blurred here, so those provisions, which eventually became 18 U.S.C. 242, its sponsor, Senator Stewart, explicitly stated that the bill protected all persons. He noted that the bill simply extends to foreigners, not citizens, the protection of our laws. He added, this bill extends the equal protection of the laws to aliens so that all persons who are in the United States shall have the equal protection of our laws. Just evidence, compelling evidence that I'm trying to share with you. In 1927, the California Supreme Court made the ruling on the right. Read number 2 in the right column. This case has been before the U.S. Supreme Court twice so that it could be overturned. Both times the court has upheld the determination made in this case, and the rulings cannot be overturned as it is constitutionally correct. K. Toshihiro versus Jordan. Citizen. United States citizenship does not entitle citizens to the rights and privileges of state citizenship. Citizens of the United States does not entitle citizens to privileges and immunities of citizens of state, since privileges and immunities of one are not the same as the other. Let's see. So just skip it around. Just hopefully this is making some sense and looking at how they've tricked us. Let me read this part here. This is out of the Federal Reporter. I guess this is Richards versus something. Oh, Richards versus State, I think. Anyway, forgive me for some to read it because it's blurred. Some of it is faded and what have you. So I apologize to you for that, for certain words that I missed or because of that. But hopefully you're able to see it. In our country, the people are sovereign, and the government cannot sever its relationship to the people by taking away their citizenship. 387 U.S. at 257. So the court held that a United States citizen possesses a constitutional right to remain a citizen unless he voluntarily relinquishes that citizenship. That's simply getting into reclaiming your sovereign state citizenship. And the other big thing too that people don't understand, and I'll read it to you, is that each state, each common law state is a country. That's why you have different laws in the different states, where it's because it's a different country. Let me read it. In 1988, Congress passed Title 28, Section 297. The law is in keeping with the intent of the Constitution. Do you know what the freely associated compact states are? They are the 50 states of the Union of the several states. Read Section 297, paragraphs A and B. What did Congress identify California state as in paragraph? Countries. Remember that each state of the Union is a sovereign state that is equivalent to Germany, Japan, France, or Belgium, etc. We band together for the limited purpose and made the U.S. Constitution a limited grant of power and a restriction upon the federal government. And reading in here, just talk about that the judges and any duly constituted courts of the freely associated compact states of reimbursement from the countries referred to in subsection. So that's what it is. And this next part, just because people talk about it, the fringe on the flag, when you walk into the court and you see that, they are not, I'll read. You have seen the fringe flag in schools, courtrooms, and all government buildings. For you, those of you who don't know, you see that there's a flag sometimes. It doesn't have this gold fringe around the whole flag. Well, people were saying, well, do you know what this means? No, it does not mean admiralty maritime jurisdiction as you have been told in the past. Although that is what's going on, and we'll get into that whole thing with common law versus maritime jurisdiction or whatever. No, what it is, and I'll read it to you. This is the flag, some type of United States code or what have you. Interpretive notes and decisions. Placing a fringe on national flag, dimensions of flag, and arrangement of stars in union are matters of detail, not controlled by statute, but are within discretion of President as Commander-in-Chief of Army and Navy, 1925. 34 OP Attorney General 483. That's what it means. So I just wanted to give you, that, understanding of this whole thing with the U.S. citizenship. And see, it was all not a huge issue until the 14th Amendment came about, which was proposed in 1866 and was ratified in 1868. Now, let me say this. This is my feeling and my part on it. Let me first read it to you. 14th Amendment, citizenship, representation and payments of public debt. Citizenship, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall bridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's what this all comes down to. They've changed the wording. Persons now, the citizen is small c, resident or reside. See? This is at the conclusion of the Civil War. Now, like I already explained to you about the newly freed black slaves. Here's my question. Because you have people who debate and say that it didn't change your citizenship status or add a new one. Here's my question to those people who say that. The Constitution was signed in 1787. What were people prior to 1868? George Washington, Abraham Lincoln, Thomas Jefferson, Ben Franklin, all these people. What did they refer to themselves as? Because they weren't calling themselves, I'm a United States citizen back then. My thing is look, why did they wait nearly 100 years to add this amendment to define what citizens we all were. People already knew what they were, right? I'm assuming, or guessing, prior to 1868. It was 81 years later, from 1787 to 1868, that this was amended to now tell you what type of citizen you were. To me, there's some trickery in there. And at the very least, when the first 10 Bill of Rights were added, that was all done, the first 10 in 1791. That's still 77 years later, you know, that they added this 14th Amendment. Because they intended to create a new class of citizen with the trickery of trying to tell you you're a U.S. citizen, you're just a U.S. citizen, this and that. That's the way I see it. It did change something, and it changed a lot. And we'll go into that when I show you different things and that you sign every day, or not every day, but that you sign and put that you are a citizen of the United States. So hopefully that explains a lot to you, and I know that was a little dry and long, but I hope that, like I said, it was very informative. The next part I'm going to go into, I guess I'm going to call it Part 3, the Social Security fraud, and we'll cover, start getting into the exact things about Social Security. Stay tuned.